Mr. Jeffrey, you have a sentencing on Jerry LeBlanc, 2 cases. All right, sir, are you Jerry LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered a plea of guilty in cause number 21-38605 to the state jail felony offense of theft, and in 22-40408 to the state jail felony offense of abandoning or endangering a child. The agreement in those cases was for a cap of 15 months in the state jail prison. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir. Yes, sir.
Are there any additions or corrections?
Not from the state. No, Your Honor.
All right, Mr. Jeffries, you may proceed.
Your Honor, I believe the most appropriate ending to this is probation. As the PSI report indicates, he would be a low risk on probation. I think just for context, a little bit of history on Mr. LeBlanc. He grew up in foster care. He did get into some trouble in his teenage years into the very early 20s. I believe the last time he got in any trouble, he was 21. He's in his 30s now. It's been 10 years since his last issue, and that was not a major issue that he had. And like I said, he was very youthful at the time. These situations, it's not a situation where he's going to go to prison forever and not come back. He's going to be back in society at some point. And what we ask is that we give him an opportunity to grow. Growth is important, and growth sometimes comes through very troublesome circumstances. In Mr. LeBlanc's case, the child involved in this particular situation has passed due to an illness, and that passing has has given him perspective that most of us want nothing to do with. And it's allowed him to reevaluate his life and to see the mistakes that have been made and to grow from it in a way where he's actively contributing to his community. He's volunteering with kids. He's giving up his time and his finances to coach youth football, taking these kids all over the place, trying to teach them the way to do things to prevent them from following the same path that he's taken. Along with that, he does have a 5-year-old daughter that he's very active with, that he has custody of 50% of the time, and he's a strong financial supporter of her. And what we're asking the court to do is to take all that into consideration, along with the fact that the PSI has him indicated as a low risk for probation, and just allow him to continue that growth.
Thank you, Mr. Jeffries. Mr. Smith?
Judge, the child that passed is the child that he left alone in the car in a parking lot at Academy while he and 2 friends went in and stole hundreds and hundreds of dollars worth of stuff, or attempted to steal. He basically says that was his buddies. He wasn't even doing it. They were all obviously working together. They covered the license plate with a rag so that they could make a speedy getaway. They didn't just go in and grab a few things. They had duffel bags full of clothing and items from Academy. He's been given probation opportunities before and was revoked. His criminal history speaks against him, and I believe I would ask for state jail time in this case.
Thank you, Mr. Smith. So I'm looking back, I'm not sure what has been the delay. These offense dates are from 2021,
Yes, sir.
and it appears that
Both,
August 27th, 2021.
and I believe November of 2022, Routine got 20 months state jail, and then Brooks got probation 2 or 5. That was a cap plea.
Okay.
Your Honor, if I could add just a information. Mr. LeBlanc's position, he understands that he's accountable for this theft. His statements are just an indicator that he did not take any property away from Academy. He knows his cohorts did, and he understands that he's accountable for that.
I guess what I'm looking at is just the length of time. I mean, obviously there's criminal history, and I don't disagree with Mr. Smith. That on paper, this does not look like you should be considered for probation in some ways because of you've been given an opportunity for probation. And just listen. Don't talk yourself out of what I'm about to do. But what I'm trying to say is that those revocations, the one revocation was back in 2014. Obviously, that's a long time ago. You were much younger. You have apparently not been in trouble since the date of these offenses, at least not here that probation discovered. And so you've been out on bond or doing whatever for some amount of time, doing the right thing. I appreciate that you're giving back. I appreciate the things you're doing, and it looks like you've grown up. You've gone through, I understand your child passing away. None of those things, however, makes it okay what you did. All right, so in cause number 21-38605, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft. I'm going to sentence you to a term of 2 years in the state jail prison, but I'm going to probate that for 5 years. You will be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 22-40408, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of endangering a child, state jail felony. Sentence you to a term of 2 years in the state jail prison, but I'm going to probate that, put you on probation for 5 years. You're also ordered to pay a $500 fine in that case, and you're ordered to follow all of the rules and conditions of probation. Part of those rules and conditions, you are to have no contact whatsoever with the co-defendants, Kendall Pushy and Marquise Brooks. You're also not allowed to go to academy. And I'm also ordering that you have to find, you're not allowed, I don't know if you're still using medical marijuana. You cannot use that.
Yes, ma'am.
Because the facts in this case looks like you were doing more than just using medical marijuana.
Oh, no.
Hang on. When there's scales and stuff involved, that's not somebody that's going to get medical marijuana. And that's what was inside the baby's backpack. All right? Okay. So if you test positive for marijuana, it is a violation of your probation. You will be right back in here facing the 2-year sentence that I gave you today. No negotiation. I just gave you the max, 2 years. Okay? If you follow all of the rules and conditions of probation that you're supposed to, then for all practical purposes, your case here in court is over. You'll be able to serve those 2-year sentences while you're out on probation. But again, the other side of that is if you violate any condition of probation, you'll be brought back here and you'll be facing those 2-year sentences that I just gave you. I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Jeffries. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir. Thanks, Mr. Smith. Thank you, sir.
In a courtroom filled with silence, Judge delivered a ruling that carried both sternness and hope. The man before the court, Jerry LeBlanc, faced charges that could have ended very differently. He had pled guilty to 2 state jail felonies, one for theft and the other for abandoning or endangering a child. The details were disturbing. On one occasion, Jerry left a child alone in a car while he and his friends went inside a store, attempting to steal bags full of items. Their license plate was covered to make a quick getaway, a clear sign this was no petty mistake. For the prosecution, this was enough to demand jail time. They reminded the court that Jerry had already been given probation chances before, only to have them revoked. But Jerry's attorney painted another picture. A man shaped by a difficult past, who had grown up in foster care, stumbled in his youth, but had tried to rebuild. The tragic passing of a child in his care gave him perspective, leading him to volunteer with kids, coach youth football, and be a father figure to his young daughter. His lawyer pleaded for probation, saying Jerry had matured and deserved a chance to prove it. The judge listened carefully. On paper, Jerry's history argued against probation. Yet the judge also saw evidence that time had passed, and Jerry had made efforts to change. Still, the seriousness of his crimes could not be overlooked. In the end, Judge struck a balance. Jerry was sentenced to 2 years in state jail for each charge, but both sentences were suspended and replaced with 5 years of probation. Along with probation came strict conditions. He must stay away from his co-defendants, avoid the store where the crime occurred, and completely refrain from marijuana use. If he failed even once, he would serve those 2-year prison sentences without negotiation. The courtroom heard a stern warning. Growth and redemption are possible, but accountability is not optional. For all of us, the lesson is clear. One reckless choice can destroy trust and freedom, but honesty, responsibility, and consistent effort can open the door to second chances. This was the bench order, where justice is spoken and lessons are left for all to hear.